country, I had to find someone in his country of birth to put an ad in the paper and not rip me off, because we did get several prices. I did find someone though here through my contacts who knew someone there. I was blessed. I also had unusual with having someone who was from a different country. But his name wasn't even on the birth certificate, but the state required us to do this. And it also delayed it more, 3 months. I think normally it's about 3 weeks or 4 weeks. So this bill addresses the right of an adult to make a decision, of which right now they are treated like a 1-month-old, a 2-month-old, a 10-year-old, which is just, it's just not fair. And we're behind the times. Maryland is so progressive, thank you, and is a leader in so many ways, but in this one we're behind. And so I'm really excited that this year's bill was tweaked, and I believe the department is supporting it this year. And it really focuses on what we need, which is not having to sever parental rights, consider them severed when the person becomes an adult. Thank you.
Thank you. Next we have Rachel.
Oh, wait a minute. I need to be on record. I asked for a favorable report on HB 214.
Okay, thank you. Is Rachel Bennett available? Okay,
Yes.
great.
Hi. Members of the committee, my name is Rachel Bennett, and I stand before you in favor of House Bill number 214. For the first 22 years of my life, I was subjected to verbal abuse and emotional manipulation from my biological mother. Because of these years of abuse, I formed an eating disorder, I used alcohol as a coping mechanism, and I considered suicide. I've spent the last 7 years in counseling trying to make peace with my biological mother's abuse, to learn healthy tools to live with the effects from the abuse, and to grow a new appreciation for my stepmom, who stepped into the role of mom when I was 8. For any abuse victim, a major part of their recovery is taking back their control. For me, that was asking my stepmom to adopt me, to ensure that my abuser no longer had her parental rights to make major life decisions for me on my behalf. You can imagine the punch to my gut when I learned I couldn't do this without my abuser's permission. Let that sink in. I've spent 7 years in counseling to recover from 22 years of abuse, and now the last piece of the puzzle to my recovery is in the hands of my abuser. Now, let me be abundantly clear. The decision to call another person mom and make it official by law is not made lightly. It's a devastating reminder that the person who was supposed to love me unconditionally was the same person who chipped away at my psyche and made me believe I wasn't worth a dime on this earth. So I sit here today asking you to take that piece of the puzzle out of her hands and put it back in mine. Take the control that parental abusers have over their victims and give it back to the victims so they can have a shot at a fulfilled life with full autonomy. Thank you.
Thank you. Judge Fairfax.
Good afternoon, House Judiciary, Madam Chair. My name is Jennifer Fairfax. I was appointed to the bench in September by Governor Moore. Prior to being appointed to the bench, I spent over 20 years as an adoption and surrogacy attorney. I worked nationally and actually globally on these issues. And the judiciary, speaking on behalf of the judiciary, we support this bill. These cases come before the court, and as I said, I brought them before the court many, many times. And oftentimes we would have to tell adult adoptees that we would have to go and get their birth parents' consent or the legal parents' consent in order for them to be able to proceed. And the number of adoptions that would not proceed because of the trauma that that person experienced, they did not want to be re-traumatized, is numerous. That coupled with cases where there was a step parent who had parented, maybe there wasn't the same level of trauma, but the child developed a parent-child relationship with that person and wanted to have that security for inheritance purposes, for medical decision-making in an emergency and things like that. But they couldn't get their biological parents' consent, perhaps because they just didn't want to do it, or they were angry over the divorce that occurred 20 years ago or 15 years ago. And so it became a real challenge. So a lot of adult adoptees were denied their autonomy, their right to make decisions. They're able to make so many decisions in their life, but they'd have to go back and get the consent from these parents. And that is a challenge for the court. and something that this bill corrects and allows that to be bypassed and let that adoptee make those decisions. And so that on behalf of the judiciary, we support this bill. Thank you.
Thank you. All right, Delegate Grammer, you have a question?
Thank you, Madam Chair. Ms. Bennett, thanks for being here today. And you said in your testimony you're 29. When were your parents divorced?
They separated when I was about 2 and their divorce finalized when I was about 4.
And you told your story about your mother. What was her involvement in raising you?
I think it would be irresponsible to say she didn't contribute anything. But as far as instrumental contributions to my raising, my paternal grandmother assumed that role until I was 8 when my stepmother came into the picture.
So it's safe to say you don't really have a great relationship with your mother.
We do not have a relationship at all.
Okay. When's the last time you spoke with her?
Mid last year, 2023. And I contacted her to actually ask consent for this.
And so you've asked her for consent.
Yes,
And
that's
what
correct.
did she say?
She said no, which is disappointing, but not surprising. And she then proceeded to tell me that I was weird for asking to be adopted by my stepmom as an adult and scolded me for asking in the first place.
What do you refer to your stepmother? How do you talk to her? What do you call her?
I call her Barb. I call her stepmom to some people. And sometimes I call her mom to people too.
You got some folks here with you today. Is she
I do.
here with you today?
She
Look at
is.
that. Is anything else you want to share with the committee?
There's a couple things that I think are really important to point out in addition to my testimony. It's widely understood that parents want what's best for their kids, right? And so when I say I'm not surprised that she isn't consenting to the adoption, what I mean is I'm well aware that her image and her ability to maintain control over me is more important to her as a priority than it is for what's best for her child. And so I believe if she had my best interests at heart as a parent she would consent to it. Of course, not without some pain with that decision, but she would consent to it. Second, I know that sometimes people have a hard time understanding that a parent is capable of abusing their child. But it happens in various forms and to different levels of severity. And while it's not the child's fault that happens, it is our responsibility to pick up the pieces of what's happened to us and make a decent life for ourselves. And for those of us that look at this adoption as an adult as the route to a better life, this bill passing is critical for that. And last, the point that I want to make is that, when I was 2 and my parents separated, the court decided that my father should have primary physical custody over my sister and I, not my biological mother. As a 2-year-old, my father should have that. And so it boggles my mind that now I'm 29. And when I turned 18, the court shifted that decision-making over to my biological mother instead of shifting it back to me. And so that's really what should be happening here. It should have shifted from the court making decisions for a minor to then putting that in the hands of the adult. I can't stress enough that I know people have a hard time wrapping their minds that this is possible, but it is possible. And it will continue to happen no matter what people unfortunately do to take steps to prevent it from happening. But if this is the road that adults take in their recovery, it's critical that this passes.
Thanks. We appreciate you being here.
Thank you.
Delegate Carden.
Chair, and thank you for bringing your compelling stories and your testimony to all the witnesses. This is for the judge. So 2 questions. The first is, it looks as if in present law, a judge can order for the adoption without consent as allowed by statute, I guess, when is there some sort of extreme circumstances that you can talk about?
Sure. Under the current statute, if we don't have parental consent, we have to do it goes under 53B22, which is a non-consensual adoption. Under that statute, and to the other witnesses' point, it talks about that the adoptee, it says child, was in the care and custody of the adopting parent for 6 months, not in the care and custody of the objecting parent for 1 year, and that the child has a parent-child bond, then you have to show that the objecting parent failed to provide financial support despite an ability to do so, and failed to maintain an emotional relationship despite it. So
So
Yeah.
there are statutory requirements. You can't just say that this is an exception and based on what I've seen and what I've heard, I'm going to award. You have to actually meet certain.
you do,
certain
you have to
statutory
have a
criteria.
trial. You
Okay.
have to have a trial.
And then can you just describe what, if any, rights a parent has over an adult child that they can stop them from doing if they choose not to allow for an adoption to another? I'm just trying to figure out what, from a legal perspective, what does the adult child lose in terms of their ability to have free reign over their decisions?
So I think I understand your question is, so if the objecting, what rights does the objecting parent have over an adult person? Well, it would be in a couple of circumstances. One, if that adult person obviously became medically incapacitated through estates and trusts, that parent would have decision-making in those kinds of
Wouldn't-
rights.
Right, but in that case, wouldn't an 18-year-old be able to, or 18 and older, be able to make an advance directive or some other legal document to make sure that they are taking away any rights that their parent, that they're
Well,
worried their parent's gonna?
Yeah, I believe that it is true that an 18-year-old could execute those documents if they were aware of them and had obviously the legal guidance to do that and understood that. I'm not sure how many 18 to 26-year-olds know that.
Right,
So they could
okay.
in that one circumstance.
But in most circumstances, you're saying that, you know, a 29-year-old, look, I didn't actually draft a will until I was like in my late 40s, but a 29-year-old, the young lady sitting next to you might not even realize, oh, wait, I could, if I can't get myself, you know, separated from my parent, I could actually do it from a legal perspective. Of course, I have to spend money doing that, right?
Mhm.
So this would be a much easier way of making sure that that is done. Is that fair to say?
Yeah, the adoption one would be an easier way to make sure and it's also a way to honor the adoptees, what they view as their family and that parental relationship they have, but it would be easier for the adoption for the adoptee. Yes.
Thank you. Thank you, Madam Chair.
Thank you, Madam Chair. Again, also, Judge, I just want to follow up on Delegate Cardin's question. That's a great example of where this would really be important. Is there any other area of a young person's life where you can think of that a parent, like an alienated parent, would gain power over an adult child that this legislation would fix?
Right. So I think you can't just look at the adult child because you then have, if that adult child has children. So you now have a grandparent. And if something happens to the adult child, you now have that when you follow estates and trust article, you're looking at next of kin. You now have grandparents that these adult adoptee or a child did not want to have in that child's life likely as well, if they severed that other relationship. And so, you know, and I would say inheritance in some ways, I've heard, you know, there is an area that says an adult child is responsible for caring for an indigent parent, or if it, you know, you're putting that adult person in a place of potentially being at risk of having to be responsible for a parent who abused them. And this would avoid that, right? They would be able to not have that responsibility to a parent.
Okay. And again, like that makes me think too, again, like God forbid if something happened to a young person, a young adult who did not have children of their own hard-earned money would also then move up to that parent.
Potentially, yes,
Okay.
based on how that was set up. Yes.
Thank you very much.
Delegate Kaufman.
Yes, Delegate Munoz is an estates and trusts lawyer, so it was interesting to see her talk shop with Judge Fairfax, and congratulations on being Governor Moore's first appointment and being from Montgomery County. But my question is, And my question is for Ms. Bennett. First of all, I'm really sorry you had to go through that, and my heart goes out to you. But Delegate Cardin outlined, some steps you could take, and with the advanced directive and the seeking legal counsel and things of that nature. But wouldn't those steps kind of be arduous and re-traumatizing for you? So this would be simpler?
I think to a degree, I think it's a fair statement that it can be a re-traumatizing process, but it comes down to what's on the other end of it. So going through the adoption process, sure, it can be re-traumatizing. And that's why mental health services are critical in this process as well. But knowing that on the other end of it, I am liberated from the control of my abuser, makes that risk a little more worth it.
Yes, I think you misunderstood my question. I tend to babble, so it's probably my fault. But would this Delegate Cardin has offered provided some other alternatives, but would the passage of this bill, I'm trying to figure out what's best for people's mental health, would passage of this bill be the best course of action in terms of mitigating re-traumatization and for mental health purposes?
Yes, it would.
Okay, thanks.
Any other questions? Thank you, panel. And please tell Vice Chair Boyce we missed her.
Thank
You're
you all.
welcome. Good job. Okay, we have the Bennetts you're signed up to testify. Barbara Bennett and David Bennett. Feel free to sit where you feel comfortable. And you can start in whatever order whenever you're ready.
Good afternoon. I'm Barbara Bennett, and I am Rachel's true mom. There really isn't a whole lot more that I can say. She has pretty much said it all, but I think I heard a lot of legal stuff, which I got, but I think when it comes down to it, part of passing this bill is allowing that adult to close that chapter of abuse. It's a mental state of mind. It's the mental health. We have a lot going on in this world right now with mental health, and passing this bill would help that process. I think that the abuser will always be there until something can put closure to it. And so passing this bill, at least for Rachel, would put closure to that horrible time frame that she's gone through. One of the things that I did while I was kind of reading about this stuff is I looked up, what does the law expect when one becomes an adult? And I think everybody's going to agree to the statement that I found. Quote, it said the legal concept of adulthood is an age at which a person gains control over their own actions and affairs and becomes responsible for the decisions that they make. Becoming an adult involves one, taking full responsibility of your life. And I believe that begins at 18. Two, making your own decisions, again, at the beginning of 18. Three, being responsible for your own mistakes. And four, fixing your own problems. So why is it that at 29, an adult can't be an adult under this ruling? So again, that's why I feel like this bill needs to be passed. We need to put the responsibility of an adult back with the adult.
Hi, everyone. My name is David Bennett. I'm Rachel's and her sister's biological father. As I don't want to repeat too many things, but as Rachel said, I gained physical custody of both of them at 2 and 7 years old. And then 2 years later at final divorce, I was awarded that permanently until the time they became adults. And it's, as has already been said, the courts made the decision that I was the best choice for them, which I am forever thankful for. But the one flaw as the law currently stands now is that once she became an adult, she's no longer has that power to make those decisions about who she wants to be her parents. I was fortunate that I met Barbara. We've been together for 22 years now. And she has always, since day one, she chose to be Rachel and my other daughter's Samantha's parent. She did that. She didn't have to. She chose to do that. And she was she's very nurturing to both of them to this day. And Rachel's made that decision that what she needs to help her close that horrible chapter in her life is to be able to make that decision of who she wants to be her mother. And she should have that right to be able to do that without re-traumatizing her. Thank you for your time.
Thank you. Any questions? Seeing none. Thank
Thank
you
you.
very much for being here. There's no opposition that I have listed. So we're going to go right into our next bill. Our next bill is House Bill 141. Delegates Pippy and Simpson, Criminal Procedure Child Abuse Victim, testimony taken outside the courtroom. And whenever you're ready.
All right, thank you, Madam Chair. Delegate Pippy, for the record, in support of HB 141. This bill deals with closed captioning television as it pertains to victims of child abuse. So currently under existing Maryland law, section 11303, if you are a child victim of abuse, there is an option for you to testify outside of the courtroom via closed circuit television. There are some strict rules that go with that provision. One of those rules means that you do not have the ability to reasonably communicate. Obviously, being able to testify outside the courtroom was upheld by the Supreme Court in Maryland v. Craig in 1990, so there is no Sixth Amendment confrontation clause issues there. What my bill does, the amended version, which we've sent to the committee, it's very narrow in scope. It simply removes the reasonable communicate language. So essentially, what the current law implies is that if a victim of child abuse can communicate but would suffer severe emotional distress, they would be forced to. Whereas with our bill, by removing the reasonably communicate language, that removes that damage to that child. To protect the defendant, we've also added language that states that the defendant must have an attorney in the room with the child while testifying. Without that attorney there can be no testifying outside of the courtroom. So that is protections for both the defendant and the victim. I'm proud to say that we have support from the Attorney General's Office, Maryland States Attorneys Association, MCASA, Children's Alliance, and the Maryland Human Trafficking Task Force. You may see letters of opposition from the judiciary, and that pertains to the clear and convincing standard which we have taken out for the amendment. So there is no longer a rebuttable presumption in our bill, so that should address their concern. The Bar Association had the same concern, which is addressed, and the public defenders referenced the confrontation clause, which I have stated, the law of the land is Maryland v. Craig. It does not violate one's Sixth Amendment right to have a victim of child abuse testify outside the courtroom as long as the rules are followed. So this is important legislation in line with keeping our community safe and supporting those that are most vulnerable. So I ask the committee for your support.
Thank you. Delegate Simpson.
Yes, for the record, Delegate Simpson, and I support House Bill 141 and ask all of you to support this as well. I was honored to be asked to sign on to this as a former Child Protective Services worker and also as a survivor of domestic violence. I think this is just common sense that, you know, we know from all the other cases that we've heard when it comes to children, we don't even hear about that severe emotional stress until they are of age, sometimes not even until they're 50 or older. This became common during COVID, or we wouldn't even have, you know, court. So let's just protect the most vulnerable and make sure that they are able to testify in a manner, because we know, you know, when it comes to these things, it can just be facial expressions or other stuff in the courtroom that you're just not, you know, people show emotion differently and fear differently, particularly when we're talking about any type of violence, whether it's child violence or domestic violence. And so let's just do the right thing and pass this bill.
Did you already provide the committee with amendments?
So We did, but I'd be
Okay.
happy to email each member with the specific amendment if that would be helpful for your committee.
I don't think it would hurt.
Okay.
There's probably a procedure that we're supposed to follow, but I think that's fine too.
Okay, thank you.
And I didn't call up Amanda Rodriguez, but if you wanted to come on up now, you can. And then we can do this as one panel and members, you can ask questions to the panel after Ms. Rodriguez.
So it's just one year.
Good afternoon, members of the committee, Madam Vice Chair. My name is Amanda Rodriguez. I am the Executive Director of Turnaround, which is the Rape Crisis Center for Baltimore County and City. I'm also a former state prosecutor and the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. We are asking for a favorable report on this bill. In terms of my credentialing, I'm a former state prosecutor and have worked in the field of anti-trafficking and child abuse for about 15 years. This bill in particular really speaks to what I hear a lot of survivors say. It's described by many of the adult victims who were children when they went through the criminal justice system, but are now adults, that the criminal justice system is actually more traumatizing than the assaults that happened against them. A lot of that comes back to, for those of you that are lawyers, you may have had this experience. If you look to the right or left of you, right? One of you is going to fail law school. That's like the old adage, or several movies where they talk about that. There's also the reality that if you think about testifying, it's look to the right and left of you and explain the most horrific sexual experience that you've ever had, or even the most wonderful experience you've ever had. You're probably not likely to do that. Imagine doing that in front of the person that has committed that heinous crime against you, and add power and control into that dynamic. And the fact that you are a child. This person has exerted that power and control over you. The reality is that these kids are not just traumatized by the system, they're also traumatized by this assault and by this person. And we have to make sure that we are recognizing that trauma. And this is a way to do that that protects both the criminal defendant and also the young person. Part of the reason that we decided to testify in person is because this would encompass human trafficking survivors. At Turnaround, we have 3 survivors that we served in the last year that were under the age of 8. So this does happen. It happens with far too great a frequency. And when described, we were discussing it as a committee. One of the former prosecutors in the room said it is literally watching someone face their monster. Based on that, we are requesting a favorable report for this bill. Thank you so much for your time.
Thank you. Questions? I saw Delegate Phillips and then Delegate Grammer. In that order, please.
So before I ask this question, I just want to note that early in my career, I did work in Senate-related cases and other cases involving children, and did family law. And I just want to understand from your perspective how it generally works today, so you can share that with the committee, and how most judges handle this in their courtrooms. And you can even use a human trafficking case. What do we see today? And is this well, let me just ask that question first.
So I think in real practice, what is happening is that victims of legitimate abuse are refusing to testify. So you have scenarios where abuse is occurring and they're terrified and they just refuse to testify against their abuser. And based on the language that's currently existing in law, a judge is basically saying, well, I think they can testify, but they're refusing to. And so the case gets settled. And so what we're doing is we're negotiating with the abusers. So, I mean, it's taking a case with evidence and this and that, and we're turning it into, we now have to negotiate a plea deal with these abusers or throw the case out. So that's what's happening in real practice. And so what we want to do is we don't want to give, I don't want to say the advantage, but I think this is a level playing field where the victim and the defendant, it's more of a level playing field where currently, because of the existing language, what we end up with is abused children that are terrified and refuse to testify, and it moves in the favor of the abuser. And so I think this fixes that.
And so in our courts around the state, judges are not using the opportunity to speak to the victims in camera. You're finding that they're not doing that?
And I'll let Amanda answer, but I think what's happening is the state, a prosecutor who is asking the victim, we need you to testify. You're gonna have to sit in front of this person. And in many cases, they refuse to. They won't do it. And so I think that's the real result. And the judge, based on the language in the law, is saying, well, it appears that they can reasonably communicate, but they're refusing to. So therefore, there's no witness. You know, the abused person is not testifying. They either let the person go or they work out some sort of plea agreement, which again is not justice. And so I think that's the real life. Is that fair to say?
Yeah, absolutely. I think, as the delegate said, a lot of the scenarios lead to the victim not being willing to testify. The in-camera piece is interesting because I've had several cases too where the judge will take a child back in camera, but those are typically civil or family law cases because of Crawford and the Sixth Amendment right to cross-examine. Oftentimes, I mean, I don't think I've ever had a criminal case where a judge would even entertain something like that, unless there was I can't think of a case that has happened. I guess if there was absolute agreement between everybody, you could do it. But ultimately, I don't know that's a right that's afforded in criminal proceedings. I do think that they're depending on, a lot of it is judge specific. So if the judge decides that this is the standard, the judge is going to employ that in a way that is fair, obviously, and impartial. But I think without having some kind of, without giving the judge more guidance on how it should be, I guess, put forward, it's difficult to say that a judge is always going to allow for this type of thing to occur. So I appreciate the language that the delegates have put in.
Okay, and help me to understand the objection from the judiciary. How are we addressing that?
So in the original format of the bill, unfortunately, that's probably the one you're looking at. We originally there was a rebuttable presumption, which means it was automatically presumed that the child could testify via closed circuit television and that the defense would have the opportunity to rebut that presumption. We have taken that out now. So the main objection that the judiciary has and the State Bar Association has was related to that rebuttable presumption. That's been deleted from our bill totally. So that was a clear and convincing standard that they had concerns with, taken out. So that's
And
no
they
longer
were
in the bill.
concerned about that because it would put them in the position of having to make some determination.
Yeah, it would add another layer of decision-making for the judge, and that's a high threshold. And so again, we want to move the needle forward. We took all that out. The only thing that we're doing in this bill is removing reasonable communicate. And then we're adding the language to protect the defendant, just as a balancing act.
And I'm sorry, Madam Chair, that was also the primary issue that the bar had as well?
Correct. But their objections were almost identical.
And have you communicated these amendments to the judiciary and the bar?
They're probably watching. I don't know, but
Sure,
no,
sure.
they'll get them. Yeah, we'll make sure they get them, and if they have some updated input, we'll get that as well.
Okay, thank you, Delegate.
thank you.
Thank you.
Delegate Grantmore.
Thank you, Madam Chair. Thanks for being here today and bringing the bill. I have a question for Ms. Rodriguez, and thanks for everything that Turnaround does. So we know broadly, one of the reasons we fail to address a lot of criminal issues, whether it be rape or something else, is our inability to procure a witness, whether it's the victim themselves or someone who witnessed the crime. In terms of rape, can you speak to the number of legitimate rape cases that we're able to prosecute and the number that we're able to convict? Like, do you have a percentage?
Sure. So I mean, national statistics are that about 6% of survivors actually feel safe coming forward and about 1% are ultimately prosecuted. So the numbers are dramatically low, and a lot of it has to do with the criminal justice system set up and how it works against survivors.
So we're estimating that 1% of the victims, most of whom are women, see justice served.
Correct.
And that number probably is due to many reasons, but one of the reasons is we can't put together a format, a system to get them in a position where they feel safe to testify against their own assailant.
That's absolutely correct.
All right, thank you so much.
Thank you.
I have one quick question, then I'm going to go to Delegate Boucher. Is there a significance behind the age 13?
So taken out. And I apologize. So the bill you see before you, that number has been taken out.
So is it minor or?
It's minor, under the
Okay.
age of 18. I
Okay.
think Maryland law, if you were under the age of 18, you're a child.
Okay,
Yeah.
perfect. Thank
But
you.
yeah, that was taken out, and I apologize. I'll send that updated amendment to everybody. But
Okay, and Delegate Boucher.
Thank you, Madam Chair. After reviewing the statements by the judiciary and a public defender, You know, it brings up all these constitutional concerns. I'm a big stickler. I don't want anything to come out of this committee that's all failed judicial review. With the amendments, do you feel confident that this bill will survive?
100%. So I read through the public defender's statement, and they may be behind me, I'm not sure, but they brought up their constitutional right to confrontation. So in America, you have a right to face your accuser. So luckily for us, there was a Supreme Court case, Maryland v. Craig, 1990, that absolutely upheld the right of a child of victim abuse to testify via closed caption television. So there is no constitutional issue with this bill whatsoever.
Thank you very much, Delegate.
Thank you.
And Delegate Phillips wants another bite of the apple.
I'm sorry, because I want to make sure we're clear, because their argument in the OPD's argument was there is a constitutional right, but it needed to be decided on a case-by-case basis. Right? I believe that's their argument. And so it has to come before court. So I just wanted to I wanted to clarify that. I wanted to ask that question if you see that the same way, so that there still may be a constitutional issue with this.
I mean, I don't see one. I think it's pretty clear. I read through Maryland v. Craig. It was verbatim the scenario in which this bill encompasses. So it is absolutely clear that a victim of child abuse may testify outside of a courtroom via closed caption television. My bill does not change any of that procedure. The only thing it does, it removes the reasonably communicate, which is just a language that is kind of a burden to our local judges, but it doesn't really have any implication on the constitutionality of the issue at all. So.
Okay, seeing no questions, that ends the testimony for House Bill 141.
Okay, thanks.
And that ends. There is no one else. I have no one else signed to testify.
No, you're
All right. So that ends the work at the desk. All right. Can we go off? Wait 1 second.